Marquise McLaughlin took a round to the chest, bled out with his partner and his 5-year-old watching. Why? He knocked a man to the ground who was arguing with his girlfriend about a parking space. When he came out of the store and saw the two going at it, this happened on your screen right now. Did you see it? If not, re-rack it, Ellie, and show it again for them so they get an understanding of what's happening. There's McLaughlin. There's the guy arguing with his girlfriend, right? She gets out of the car. Boom. He pushes him. What does the man do? He pulls out the gun, and right there, he fires at him. Why did we stop it? Well, because you've already seen enough in terms of you didn't see him lunging towards Michael Drejka, the man on the ground. You don't see that. But I don't want to show for his family and for some of you who are sensitive, him getting shot in the chest. He went back into the store. She tried to give compression. His 5-year-old sat there and watched him bleed out. The Pinellas County Sheriff, Pinellas, Florida is where this happened. That's the county. Said the law is clear.
He had to shoot to defend himself. And those are the facts, and that's the law.
He's no simpleton, by the way. He's also a lawyer. So he's a lawyer and the sheriff. Michael Drejka is the shooter. He's home tonight or wherever he wants to be because of the Stand Your Ground law. At least 24 states have similar legislation. Florida recently, arguably, updated it to make it easier for someone like Drejka to kill without consequence. The reaction to this, understandable. Emotions raw, running high. People want justice. They don't believe you should be able to shoot somebody and walk away like this with such a low standard. We know this isn't the first time, by the way, that Drejka apparently started trouble over this issue. How so? Listen.
He said he'll shoot me, called me and stuff like that. So, I think it's a racial issue.
Check the reporting. Store owner also knew this man and knew his tendency to have a pet peeve about people who were parking in the disabled spot. All right, so let's dig into the case. Ariva Martin and Mark O'Mara are with us right now. O'Mara, it's good to see you again. Ariva, good to see you as always.
Good to see you.
So, are you okay with the application of law in this instance, Mark O'Mara?
Very tough call. We have to understand that the foundation of it is that we all have an absolute right to self-defense. That was sort of upgraded, if you will, by the Stand Your Ground law in Florida that said that right that we have, that Castle Doctrine right to protect ourselves in our home, we can now do that on the street corner. That's what the Stand Your Ground statute does. What it really says is before you have to retreat, or instead of having to retreat, you can meet force with force. That, as you said, was upgraded. If the reasonable fear of imminent great bodily injury exists.
Great bodily injury. So that's the standard. Correct. Mark, appreciate it. Let's bounce it over to Ariva. You saw what happened. There are no other facts in the case. Drejka, 47, McLaughlin in his 20s, bigger man, no question about it. He shoved him on the ground. There is no secondary assault by McLaughlin that's on the video, and this is all of the video that exists. We just stop it where he gets shot because I don't want to show that to my audience. So, serious bodily injury. Ariva, what does it mean in this case?
Wow. What concerns me most about this tape, Chris, is we see the victim in this case pause. We see him back up. We see the shooter pause before he takes that shot. So I don't think the story begins and ends with this video. And also my biggest problem with this Florida law is the inconsistent nature in which it is applied and the racial imbalance. There's been a study that was done that says 79% of people that kill black people using this defense, they get off, versus 59% when a white person is the victim of a shooting. So we can talk about this law, we can talk about your right to defend yourself, but we can't talk about that in a vacuum without acknowledging the racial issues that come into play. And that sheriff, looking at that tape, could have reached a completely different conclusion. The case law is all over the place in Florida in terms of how this law is applied. So I don't think the sheriff had to reach this conclusion at all. And we saw in the Trayvon Martin case, which was Mark's case, what it took to get the state's attorney in that case to actually file charges. This case has been referred to the state's attorney, and maybe charges will be filed, as I believe they should be.
All right, so let's take up that part of the case, Mark. A year ago, there was an update to the law that shifts the burden. It used to be, as it was in your case with Robert Zimmerman, that you had to plead as an affirmative defense and argue that Stand Your Ground should apply and wipe out the homicide. The culpability for the homicide. Now, it's on the prosecution to do it. So the sheriff says the law is clear. Who reviews it? What is the chance for further justice?
Well, and you're right, because back in 2014, what they did was they said, once I, as the criminal defense attorney, present a prima facie case of self-defense, if I show that I think I acted in self-defense, now the state has to disprove that self-defense by clear and convincing evidence at the stand your ground hearing. Don't forget, they always have to disprove self-defense at the trial. That's beyond a reasonable doubt. So there's no question that Florida, both in 2005 when they created the stand your ground statute and 14 when they amended it, is making it, quote, easier to get away with shooting somebody because you argue it's defense. But the point is, it's still got to be imminent. Chris, if you punch me in the nose and break my nose, I can't shoot you because of that. I can only shoot you if I reasonably think you're going to do it again. And that's the problem with the videotape.
Well, by the way, I have a
today.
problem with that
There's
anyway,
no evidence
because
of
I
that.
don't know that punching someone in the nose is fear of death or serious bodily injury, but that didn't even happen with McLaughlin. He just shoved him. That's all that happened, is what you see there in that tape. What do we know about the review that's going on at the state level?
Well, we know that they're going to look at it.
So they're looking at it.
Go ahead,
Ariva,
Ariva.
what's the chance that we believe that there are going to be some charges here filed? Just charges.
I hope there are going to be charges filed, and maybe some defense lawyer like Mark will get to plead the case for this shooter. But to not arrest him and not to file charges, I think, is an injustice in this case. Again, when you look at the inconsistent nature of the way the law is applied, you can't take race out of this case.
Listen, we're going to have to talk about this a lot more. We have to see what the state does and why they do it, and I'm going to call on you both to come back, and I count on you for this.
Absolutely.
All right,
Absolutely.
Ariva, thank you very much, Ariva Martin. And to know, Mark O'Mara didn't just represent Zimmerman. He was part of this group that was trying to get language added to this law, that you have to be able to have some type of thought process and have tried to get away from a situation before you kill who you think is your assailant.